Okay, welcome to the Week 11 podcast on freedom of information and right to information. This is podcast 3 for Week 11. The Freedom of Information Act is the Commonwealth Act, a 1982 Act, and the Queensland Act is a newer piece of legislation which came in 2009, the Right to Information Act. So at Commonwealth level, the introduction of the FOI Act was part of a package of reforms which also brought in the ADJR Act. And in Queensland legislation has become a model for the Commonwealth and other states. Other jurisdictions have amended their legislation to follow the Queensland Right to Information approach. So, as we discussed earlier, freedom of information and right to information involves the right to access your own documents from government departments. Some statistics for you, which I nearly gave you in the first part of the lecture in relation to the Ombudsman, but the figures are actually in relation to freedom of information and right to information. The most recent annual report for FOI at Commonwealth level showed that in the 2015 to 2016 year, there were 37,996 requests received under the Freedom of Information regime. The main departments which received these requests were the Department of Immigration and Border Protection, which was a much higher figure than any other department at 20,889 requests. The second was the Department of Human Services at 4,501 requests for right to access information, and at 3,436, the Department of Veterans Affairs. So you may know that the Department of Immigration and Border Protection, a number of the requests may be made in relation to accessing previous visa applications by applicants and accessing data, including interview transcripts that they, in relation to interviews they may have had done earlier in time. So recently, people who arrived by boat were able to apply for a temporary protection visa or a safe haven visa after being invited to do so by the government, by the Department of Immigration and Border Protection. And in order to do so, it was necessary for many of these people to access their application and their arrival information from when they arrived in Australia, because in many cases it had been several years since they had arrived in Australia and they could not remember what they had said at an earlier time. So the benefit of being able to access those interview transcripts was very useful. However, you can see the figures are so high, there were a number of delays in accessing that information, and often taking longer than the 30-day period recommended. In relation to the Right to Information Act, the figures are also quite high. So in Queensland, in the 2015 to 2016 year, there were 13,099 applications for access to information and amendment to information. So we'll discuss the amendment option later on in this podcast. And the most common departments in relation to the Queensland Right to Information Act were requests to Queensland Health, the Queensland Police Service, and Infrastructure, Local Government and Planning. In Queensland, we also have the Information Privacy Act, which we'll be discussing later on. So why is access to information important? So So modern governments accumulate huge amounts of information due to an expansion of government powers and an increasing amount of information available to the government. So the bureaucratization of government and things such as delegation of government functions and numerous policy statements and documents. There's also a significant impact due to the changes in technology through the use of electronic databases and the ability for private providers to provide information to the government. And there are broader socio-legal developments, for example, the war on terror and greater intelligence gathering powers of the government. It's also valuable in itself for people to be able to access that information relating to themselves. So it respects the dignity of the individual unless consent has been provided for that information to be kept. It promotes transparency of government processes and decision making. It ensures accountability as a check on government action, and it makes sure everything is above board, and it enhances public debate by fostering informed choice. Government should be representing us, so information held is ours as they act on our behalf. Access to that information may assist and enhance other mechanisms of administrative law. So one of the key areas that's relevant to our consideration in administrative law is by identifying a legal error that is judicially reviewable. So once a decision is made by a decision maker, if there is a possibility of seeking judicial review, then it's a requirement to obtain and read the statement of reasons and other documentation relating to the decision and the application. And it may involve, for example, as I said earlier, seeking the original interview transcripts to see what has occurred and whether you can identify a ground of judicial review that may assist. So what are the disadvantages of access to information? So does freedom of information stultify government processes? If the government knows all processes will be open to scrutiny, will it be more cautious in their decision-making processes? Are there some kinds of information that might be considered too sensitive or dangerous to disclose? So the most frequently referred to in this sense is information about national security or foreign relations. What about the individuals that the information relates to? So it may be private or commercially sensitive information, for example, in relation to government tenders. How does the government spare the time and money needed to publish all this information? So the time, for example, taken in processing requests, as I said earlier, in relation to the large numbers of requests made to the Department of Immigration and Border Protection, there's often not enough staff to process those requests, and there can be quite extensive delays as well. So there's occasionally a backlog in those requests. And can there be such a thing as too much information? Let's have a look at the objects of the Freedom of Information legislation, which are contained in Section 3 of the FOI Act. The objects of the Act are to provide access to information held by the government for the Australian community. The most significant part of that part of the objects is Section 3, subsection 2. The Parliament intends by these objects to provide Australia's representative democracy, to promote Australia's representative democracy by increasing public participation in government processes and increasing scrutiny, discussion, comment and review of the government's activities. The Parliament also intends by these objects to increase recognition that information held by the government is to be managed for public purposes and is a national resource. So there's a tension there between cost, confidentiality and efficiency, and on the other hand, the broader ideals of administrative accountability. Let's have a look at the functions of the FOI and RTI legislation. So generally, FOI legislation performs the following functions. It imposes a statutory duty on government agencies to publish and make available certain kinds of information concerning their operations. So there are increasingly proactive disclosure obligations placed on the government to provide information before they are asked to do so. It also creates a legally enforceable right of access for every person to documents held by an agency or minister. It imposes limitations upon and exceptions to the general right of access. And it provides a mechanism which provides that people who gain access to documents relating to their personal information and affairs may institute proceedings to have those documents amended. So in some cases, there may be a need for an applicant to have those relevant pieces of information amended in the government department. So sometimes, for example, there might be a name that is recorded incorrectly or a date of birth that is recorded incorrectly. So, for example, if someone has come to Australia as a refugee and they've been part of a visa application with other family members, they may have come in with a more distant relative or someone who is, for example, their aunt or uncle, and at the time they've arrived, it hasn't been clear in the interview process what their name is due to the situation back in the country of origin, and they may arrive on a visa that is in someone else's name, not through any fault of their own. So in that case, an application may be made to amend their name, or sometimes this may also apply to a date of birth that is recorded incorrectly. Let's have a look at the more recent reforms in relation to freedom of information and right to information. So there has been a change to a focus on proactive disclosure policies. These are to allow access to information and the ability to amend if any errors are found. In Queensland, there's been more substantial change and radical reform under the Bligh government in 2009. So first of all, the Solomon Review report in 2008 constituted a fundamental reappraisal of the FOI concept. So rather than a section by section review of the Act, and it resulted in the Right to Information Act in 2009 and the Information to Privacy Act in the same year, both commencing on the 1st of July 2009. So Queensland has been a leader in this case. So the changes were made under the Bligh government with respect to the culture of secrecy in the public service, and the Bligh government changed the model from a pull model to a push model. So the idea is that disclosure of information be made even before these requests are lodged. The Commonwealth Government and New South Wales and Tasmanian governments have also followed similar reforms to those that have been made in Queensland. In the Queensland Act, Section 23 creates a legally enforceable right of access to the documents of an agency. So an agency includes a government-owned corporation and its subsidiaries, but not a non-government corporation or business corporation. It also provides a right of access to the documents of a minister. The term document of an agency is defined as a document with which the agency is entitled to access, and a document under the control of an officer of the agency in the officer's official capacity under Section 12. So as you'll see The term agency, as I stated earlier, does include government-owned corporations and their subsidiaries, but doesn't include those non-government business corporations, as clarified in Davis and City North Infrastructure. City North was a company overseeing the building of the new airport tunnel in Brisbane. Mr. Davis sought access to the documents relating to it as he was living next to one of the tunnel chimneys or smokestacks. The issue was whether City North was subject to the Right to Information Act. The court held that City North was a government business corporation, but not a government-owned corporation, and was therefore not subject to the Act. This was because it was incorporated under the Corporations Act. So this was a disappointing result because it was a test case under the new legislation. How does the new Act in Queensland differ from the old Freedom of Information approach? So you'll see that the new Act seeks to establish a culture of proactive disclosure, which is one of its most important features. So it establishes a regime for accessing government information based upon a legislative assumption that persons are entitled to access government information unless on balance disclosure is contrary to the public interest. So Section 3 sets out the objects clause in relation to the Act, and Section 44 subsection 1 emphasises that pro-disclosure bias of the Act. So there's a presumption of maximum disclosure and making it easier and cheaper to apply for information under the Act. You'll see Section 47 subsection 2 sets out a range of narrow exemptions. So it's Parliament's intention that the grounds of exemption are to be interpreted narrowly. You'll see the exemptions referred to on the following slide. Section 47 allows an agency to refuse access to a document where under Section 3A it comprises exempt information under Section 48. So this includes documents such as cabinet documents, executive government documents, documents protected by legal privilege, or under Section 47(3)(b, disclosure would on balance be contrary to the public interest. So there's the public interest test exemption, which is new in Australia. There are some other less common grounds for refusal to access under Section 14, and these include where there's information relating to a child's personal information and that disclosure would not be in the child's best interests, or where there is healthcare information that might be prejudicial to physical or mental health or well-being of an applicant if it is disclosed, or otherwise if the document is non-existent. Of course, it's not possible to provide the document. So let's look at that public interest test exemption that is set out in the Act. So the public interest test exemption is the most significant feature of the Queensland Act and has also been adopted, as you'll see, by the Commonwealth, Queensland and Tasmanian governments. So the task is to determine whether disclosure of the requested document would, on balance, be contrary to public interest. So these two sections work together, Section 47, and then you need to refer to Section 49 and Schedule 4, which specify a step-by-step process to be followed by decision makers when applying this exemption. So it sets out Section 49, a pro-disclosure policy when applying this exemption. It also sets out factors which should not be taken into account. For example, the government would lose face, or the information relates to a senior official within the government. So you'll see those factors are set out. Under Section 49, subsection 3, there are 7 steps required. You need to refer to Schedule 4, which is broken into 4 parts. So you'll see Part 1 looks at factors irrelevant to public interest, as I mentioned before. Part 2, factors favouring disclosure in the public interest. So, for example, oversight of public funds and to enhance accountability of government. Part 3, factors favouring non-disclosure in the public interest. And Part 4, factors favouring non-disclosure in the public interest because of public interest harm in disclosure, for example, damaging relationships with other government or prejudice to national security, law enforcement and public safety. So a broader community good to be protected. This is a complex process which may require the decision maker to take into account a number of different factors. So in some cases, non-disclosure may be in the public interest for the broader community good, and some of those factors I mentioned may be in the public interest because of public interest harm in the disclosure. So it was previously a simpler process for the government to justify why it would not release that information. So the focus of public sector information access is now the push model. So the concept of public sector access is a flow-on development from the new proactive disclosure or push model of FOI and RTI reform. So this public sector information access recognises that government information is a valuable asset which can be shared. The new model of freedom of information and right to information regimes requires governments to adopt public sector information access regimes and protocols to allow direct public access to government data sets on websites. So this recognises the value of information to, for example, public interest groups and journalists. In addition to the Right to Information Act and Freedom of Information Acts, there's also the issue of information privacy. So at Commonwealth level under the Privacy Act 1988 and in Queensland under the Information Privacy Act 2009. So under the Privacy Act, it talks specifically about government obligations with respect to the protection of information. So there are new principles which involve mandatory reporting for data loss, for example, providing unintentional access to information. There were some major amendments recommended by the Australian Law Reform Commission in 2008, which were then adopted and implemented by the Privacy Amendment Act in 2012, commencing in 2014. So the most significant recent reform is the establishment of the Australian privacy principles. Metadata is also considered personal information under the Privacy Act at Commonwealth level. In Queensland, the Information Privacy Act 2009 has a number of important provisions. Chapter 2 establishes individual privacy principles and national privacy principles, and Chapter 3 establishes a personal information access and amendment regime, which was previously contained in the old Queensland Freedom of Information Act. This regime applies to the same entities which are subject to the RTI Act, so departments, local governments, government corporations and public authorities. So therefore interlinking all of these information regimes. Let's have a look at the revision questions in relation to freedom of information and right to information. Which of the following is not the right law to consider for accessing information? You'll see a range of options there. A, the Archives Act 1983, the Public Records Act 2002. B, the Information Privacy Act Queensland and the Privacy Act Commonwealth. C, the Administrative Decisions Judicial Review Act 1977 and the Queensland Judicial Review Act 1991. Or D, Freedom of Information Act at Commonwealth level and the Right to Information Act 2009 in Queensland. So the best answer, which is not the right law to consider for accessing information, is C. So obviously it relates more clearly to judicial review rather than accessing personal information held by the government. And our final question, under the Right to Information Act, a government agency can only refuse access to documents where? Which one of these is the best response? A, it is a threat to public safety, for example, national or state security matters. B, the disclosure of certain information would constitute contempt of court or parliament. C, it comprises exempt information or disclosure would be contrary to the public interest. And D, it comprises evidence relating to polycentric high-level decision-making such as cabinet decisions. So the best answer here is that the Queensland government agency can only refuse access to documents where C, it comprises exempt information or disclosure would be contrary to the public interest. So you need to refer to Section 47, subsection 3A and B of the Right to Information Act here. Okay, thank you. That concludes our podcast on freedom of information and right to information.